is Alan Haley, and I'm the Director of Development and Communications for Lawyers Committee for Better Housing. Welcome to tonight's episode of Tenant Thursday, where we will be talking about what to do to get your security deposit back. Lawyers Committee for Better Housing is a 40-year-old organization that advocates for renters facing unjust evictions and living in substandard housing. We began our history as an organization in Rogers Park, and we are now a citywide organization advocating for renters citywide. One of our long-standing community partners is the Metropolitan Tenants Organization. And tonight we are honored to be joined by Joan Fenstermaker, an MTO board member and volunteer attorney, and Sally Robinson, one of LCBH's staff attorneys. So before we dive into the topic, Joan, if you would please introduce yourself and tell our audience a bit about what you do and what MTO does.
Sure. Thanks for having me. My name is Joan Fenstermaker. I'm a private attorney. I represent tenants in the city of Chicago. And I'm also on the board of the Metropolitan Tenants Organization. MTO is a tenants' rights organization whose goal is to educate, to organize, to empower tenants to have a voice in the decisions that affect the affordability and availability of safe, decent, affordable, accessible housing. I am on the board of directors, and I am also on their attorney referral list. So a good chunk of my day is spent answering questions from callers who have called the MTO hotline, and MTO has referred them on to me to answer their questions.
Oh. Sorry, I was muted. Sally, would you please tell our audience a bit about yourself and what you do for LCBH?
Sure. My name is Sally Robinson. I've been a tenants attorney since 2009, although the bulk of my practice was in New York City. I joined LCBH in 2019, in May 2019, as it happens. And I have been basically doing eviction defense. I've also been working on a number of policy issues. Recently, I've been working on the Cook County residential landlord tenant ordinance, which will become effective June 1st, so in 2 weeks. There is an effective part of the law now which prohibits against lockouts in suburban Cook County. I think Joan will probably tell us a little bit about the Chicago ordinance, but those parts of Cook County that are not covered by Chicago or the Evanston ordinance or some other areas that have ordinances will now have some of the same rights, including the security deposit regulations. They're very similar in the Cook County ordinance and the Chicago ordinance. So I do some policy work. I mainly do eviction defense, and I think that about covers it.
Wonderful, thank you, Sally and Joan. Maybe to get started, if we could just sort of define our topic and just describe briefly what is the security deposit. What is implied by that term? Joan, or if you want to respond to that.
Sure. A security deposit is an amount of money that a landlord usually requires a tenant to pay up front to guarantee that the tenant complies with the terms of the lease, that the tenant pays all of the rent, that the tenant leaves the property in undamaged condition. The security deposit remains the tenant's money. And that is one of the reasons that the city of Chicago has determined that the landlord has to follow very specific rules before a landlord can take the tenant's money, that is to keep the security deposit.
Right, thank you. Are there any regulations around security deposits that tenants should be aware of?
in the city of Chicago, there are very strict rules that a landlord must comply with. A landlord has to disclose to the tenant either on the written lease, or if it's a month-to-month tenancy, he has to disclose to the tenant otherwise in writing the name and address of the bank where the security deposit's being held. The landlord must give a tenant a written receipt for the security deposit that contains very specific information. The landlord must hold the security deposit in a separate interest-bearing account within the state of Illinois, segregated from all of the landlord's money. And the landlord has to comply with really specific rules if the landlord intends to not return the security deposit at the end of the tenancy. So within 30 days from the date the tenant moves out, the landlord has to send the tenant a written notice stating, I'm not going to return part of your security deposit or your whole security deposit because the property is damaged or there was unpaid rent. And if the landlord's claiming that there is property damage, the landlord has to give the tenant an estimate of what those damages are with an estimated dollar amount. If the landlord does that, if the landlord gives an estimate of damages, within 30 days from when that estimate was given, the landlord has to follow that up with actual paid receipts showing that the landlord actually paid to have those alleged damages repaired. Otherwise, if the landlord doesn't do those two things, the landlord has to return the full deposit plus interest within 45 days from the date the tenant vacates. The landlord also has to pay interest on that security deposit within 30 days of the end of each 1 year period of rental.
And I just wanted to add one more thing to that, which is that there are very strict rules for security deposits, and there are not very strict rules for move-in fees. So unfortunately for the city of Chicago right now, there is no prohibition or much regulation for a non-refundable move-in fee. In the Cook County ordinance for suburban Cook County, there is a provision stating that they can't call a deposit something else or try to evade the laws for the deposits by calling it something else. So maybe we will be able to effectuate that change in the Chicago ordinance at some point.
Yeah, that's really interesting. That came up last week. Our topic was understanding your lease. And Carl Sessions, one of LCBH's attorney, was our guest. What are move-in fees relatively new? And I mean, what are you seeing in terms of the transition to a move-in fee as opposed to a security deposit?
So yeah, it's as time goes on, we're seeing fewer landlords take security deposits and more landlords take non-refundable move-in fees. And as Sally said, there's really no limit on that in the city of Chicago. So we have seen some very high non-refundable move-in fees that don't really correspond with any actual expense that a landlord would incur from one tenant to the next. They're just sort of arbitrary and often very large. And a lot of times tenants don't even realize that it's a non-refundable move-in fee. They just know they're paying a large chunk of money and sort of assume that it's a security deposit.
So that is something to be aware of. If you're handing over money, you want to know whether or not this is, something that if you're handing it over with the expectation that you're going to get it back, you should, be very clear about whether or not the landlord is considering this a deposit that is returnable and you should get a receipt for it, or if it's a move-in fee. And, I think you could potentially sort of assert yourself at that point and say, well, what is this related to? Although there aren't rules for that, it may be a point where a tenant may want to, bring up, hey, I know that this isn't a security deposit, so what is this money actually being used for at this point?
And something we've seen more of lately too is a landlord who doesn't take a security deposit, but takes a fairly large move-in fee. And then after the tenant vacates, claims, well, there's a whole bunch of damage that you owe me for, tenant. So, here's a large bill. I expect you to pay this to me because there's damage for the apartment, damage to the apartment.
Wow. That is very concerning. I guess without straying too far off the questions we had talked about, is that something then in the lease? Is that something if you're asked to give a move-in, pay a move-in fee? Is that something that would be clear in the lease, or how do you get to that understanding? Just to follow up on Sally's point.
So a move-in fee in most of the leases I've seen isn't really designated as being for any particular thing. It's just a fee that a landlord charges a tenant prior to the time they're allowed to move in. And it really has no relation to a claim after the tenant moves out for damage. And, most leases will have some boilerplate language in there that says a tenant is liable for any damage to the property. And sometimes we'll see after a tenant has moved out, the landlord threatens to sue, says, I'm going to take you to court and sue you for all of this damage I'm claiming that you caused to the property. And I'm going to, try to make you pay my attorney's fees. So it is something to be very, very cautious about for tenants. If you are, and I know this is a little bit off topic here, but I always tell people, please document the condition of the property when you move in and document the condition of the property when you move out. You just can't be too thorough to protect yourself.
Yeah, that's, I wonder, Joan, if you would elaborate on that, because my next question was going to be, if you have a security deposit, what do you do to best position yourself to get the security deposit back? Or if you had a move-in fee, I imagine some of the things you would do to get a security deposit might be the same in terms of making sure you don't end up having claims that you damaged the apartment and a landlord seeking to get a move-out fee from you.
Correct. So I always recommend to people that, take a video of the apartment when you move in. Most phones, if you take a video, it's going to show a date stamp on it. And you can't be too thorough. Show, the walls, the ceilings, the floors, inside cabinets, show the appliances. Just very thoroughly document the condition. And it wouldn't hurt to, if there are some problems that you notice, to send an email to the landlord. Hey, we've just moved in and I've done a walkthrough and I see these issues, and these aren't necessarily things I'm asking you to fix, but I just want to make a record of it so when I move out, you don't think this is something that I did. And then, the same thing when you move out, again, just very thoroughly document the condition. Obviously, you want to, if you've damaged something, you want to try to repair that before you leave. Make sure you leave the apartment in relatively clean condition and just very thoroughly document it. Take a lot of video. I can't stress too much. You can't be too thorough in documenting the condition of the apartment.
And I'll just add, I think that definitely is something when you're in the rush of moving in and you're excited and you're trying to, everybody's, got so much on their plate when they're moving into an apartment, and, it just seems to an apartment and, it just seems like one more thing. They've already signed the lease, they've dealt with the landlord. They don't want to have to think about any more paperwork with the landlord. But, so trying to be mindful about documenting that at the beginning, before any problems arise, but also document the security deposit. If you do pay a security deposit, as opposed to a move-in fee, sometimes landlords leave it off of the lease. Well, that might be a violation. But if you're depending on the landlord to put it in the lease, the amount of security deposit, then you really don't have a backup documentation for yourself. And that, so although the landlord is required to provide you with a receipt, sometimes they don't. So just, ensure that you have some way of documenting the amount, the date that you paid it, and hopefully you can also get the person who you paid it to, or the landlord's name and address, so you could follow up.
So I'm wondering, Joan, if any of our viewers are maybe recent college graduates and are going to be renting for the first time, or maybe new to Chicago and renting in Chicago for the first time, and the landlord is requiring a security deposit. Are there any limits on how much the landlord can charge for a security deposit?
Not in the city of Chicago. No, not in the city. There is not.
If you've so you've moved out, you've done your due diligence in terms of documenting what the apartment looked like when you moved in, and then you did it again when you left. When should you expect to get your security deposit back?
So unless in the city of Chicago, if the RLTO applies, unless the landlord has sent you that statement within 30 days saying this is the estimate of damages, the landlord has to return your full deposit to you plus any interest, which is only going to be a tiny bit of money for the interest, but the full deposit plus interest within 45 days from the date that you moved out. And I guess another thing I would say too is a lot of people think it's not a real big deal. My lease ends on May 31st, but I'm not going to be out till June 1st. But it's just one day. Who cares? And I just say that's something to be very careful about, because you could find yourself on the hook for another month's rent, or even worse in some circumstances. So move out by the date that you're required to move out by. Return the keys to the landlord. If you can, get a receipt from the landlord that you returned those keys.
And what can you do if so time's elapsed, you haven't received the security deposit back, there were no claims that you had damaged your apartment? What can you do to advocate for yourself to get that security deposit back?
So the Metropolitan Tenants Organization has an app called Squared Away. If you wanted to, you could use that, or I think the LCBH has a similar app that you could use to write a letter to the landlord yourself. But the really nice thing about the residential landlord-tenant ordinance is that it's fee shifting. So it says that if the landlord violates the law with respect to your security deposit, and you have to hire an attorney to get your deposit back, the landlord's going to have to pay that attorney's fees. So there are a lot of attorneys out there that handle these types of cases at really no upfront cost to the tenant, and the landlord has to pay the attorney's fees. Likewise, if the landlord has violated the law, hasn't returned your security deposit, hasn't paid interest, hasn't given you a receipt, has commingled your security deposit, has done any one of those things, the ordinance says the damages for that is 2 times the amount of your security deposit. So, it's definitely something for tenants. If the landlord's not giving your deposit back, you may think, oh, well, it's not a lot of money, it may not be worth pursuing. The RLTO kind of helps you with that, and likely will make it worth pursuing for you.
So, I can imagine some people you might move into an apartment, you really like where you're living, and you stay there for a while. And then when it comes time that you decide to move, perhaps the building ownership has changed. How might that affect getting your security deposit back? What should you be aware of or do in that kind of situation?
Well, if you paid a security deposit to one landlord and that landlord sells the building to someone else, both of the landlords, old landlord and new landlord, have to notify you in writing of that sale and that your security deposit's been transferred. If the landlord that you paid that deposit to doesn't do that, doesn't send you a letter that says, I've sold the building to landlord B, this is their name and address, and I've transferred your security deposit to them. If the first landlord doesn't do that, they stay on the hook for your security deposit. So if the new landlord at the end of your tenancy doesn't return your security deposit, both of them are in trouble for that. Both of them are on the hook for the return of your security deposit. And the new landlord who's purchased the building also has to notify you in writing. Hi, I'm your new landlord. This is my name and address. This is how you can contact me. I'm holding your security deposit and it's now being held in this bank.
This has been very informative. Joan or Sally, are there any other bits of advice or other things that renters in Chicago should know about getting security deposits back that we haven't covered?
I don't think so. I would just say, it does get kind of thorny if you think that you have a security deposit question or issue. It wouldn't hurt to visit either the MTO's website or call their hotline, get squared away, or visit our website because it's a lot to retain. I don't think these rules are very intuitive. In other words, it's not just going to naturally necessarily occur to you. So as Joan was saying, you have some pretty strong incentives to follow up on your rights if the rules are broken. So double check,
So this week and last week's topic have been a bit of a change for us much of the past year since we started hosting Tenant Thursdays. We've talked about COVID and renters' rights amid the pandemic. And our plan next week is to return to that topic and specifically to be addressing the question of the availability of rental assistance funds. And sort of maybe team that topic up next week. Sally, are there any bits of news or updates around rental assistance funds that may be available that you would like to share with our audience?
Sure, absolutely. The rental assistance portal for the state of Illinois, which Chicago tenants can benefit from, opens up on Monday. So it's very timely. The way that the state administered funds, which are actually they're federal funds, but they're going to be given out through a portal that's run by the state of Illinois. Those funds are you've got to apply through your landlord. So if you're interested in getting rental arrears assistance, you owe back rent. You want to notify your landlord that the portal opens up on Monday. There'll probably be some information on the governor's website. There's probably information on I know there's information on the IDA website, and there's hopefully maybe we could get some information up on Facebook about the portal information. But your landlord is the one who should start the application. If your landlord doesn't want to go through the application, there will be an opportunity to try to get to access those funds for tenants. And the state of Illinois at this point is saying that they believe that they will be able to honor all of the eligible rental arrears applications. So there's quite a bit of money that's been allocated for this. It's not a lottery system. And they believe that they will be able to pay back rent for a large number of people in Illinois who may owe back rent. So we encourage you to check in next week for more information about that, and otherwise to seek out the information to send to your landlord to get the process started. Mm-hmm.
Great. Well, that sounds promising. Sally, thank you for that update. Joan, thank you for joining us tonight, and for all you do for MTO and the collaboration we have between our organizations. So with that, we will call this a wrap, and we hope to see many of you back next week when we talk about rental assistance. So good night, Sally. Good night, Joan. Thanks again.
Thanks, Joan. Thanks, Alan.